Welcome, everyone. Thank you for joining us today for since the second day of our visit with Professor John Tasioulas. I'll say a few words about today's format and introduce the speakers as well. So today's seminar is going to be devoted largely to discussion of the Emet lecture that Professor Tasioulas presented yesterday on the question of whether and what role does dignity play as a foundation of human rights. We're going to begin with two commentators leading discussion in which Professor Tasioulas will reply in turn, and then leave the most of the bulk of today's this afternoon's discussion for questions and general discussion. So I'll begin by just introducing our panel of speakers. Today, Professor John Tasioulas joins us from the University of College London, where he's a Quain Professor of Jurisprudence. Prior to joining UCL just this past January, he was previously reader in legal and moral theory at the University of Oxford. He's previously taught at the universities of Glasgow and Melbourne. His primary work and research and publications line a few general areas. He works in the philosophy of crime and punishment, moral philosophy and metaethics. He also works in philosophy of international law on issues such as state sovereignty, international customary law, international crimes as well. And for which today's discussion is going to focus, he also works and is preparing a manuscript on the philosophy of human rights. Our first commentator will be Louis-Philippe Hodgson, who's associate professor at the Glendon College here at York University. Professor Hodgson has received his PhD from Harvard in 2006. He works mainly in moral, political, and legal philosophy, and especially Kantian political theory at the international level. So Professor Hodgson will be giving us the first commentary. And to his left, we have Professor Dan Priel, who's assistant professor at the University of Warwick. But we're very glad because we have him this year as a visiting assistant professor at Osgoode Hall Law School. Professor Priel works mainly in general jurisprudence and a variety of questions and methodology, the nature of law and legal obligation. Has published several leading articles in many of the prominent journals in philosophy of law, and we're very glad to have Professor Priel with us today as well. So briefly, our format, Professor Hodgson is going to begin with his commentary, then Professor Tasioulas will take a few minutes to reply, and then we'll move to Professor Dan Priel's commentary, and again, Professor Tasioulas will have a few minutes to reply as well, and then that should leave us with a good hour or so for general questions from the audience as well. So, Professor Hodgson.
Right. Thank you. It's a great pleasure to be commenting on this paper. I found it extremely interesting. I learned a lot from it, especially since, and I want to say this right from the start, I'm not an expert on the vast and burgeoning literature on human rights. It's become a whole subfield of political philosophy, and there's obviously a lot that I still have to learn about it. So what I do in this comment is mostly to raise some questions about the kind of approach that Professor Tasioulas takes. And these are questions that I raise in good faith. I'm hoping that the answers will help me understand what's going on better. The main issue I want to raise concerns this, the way in which Professor Tasioulas rejects what he calls political conceptions of human rights. And I guess I see a lot to be said in favor of political conceptions of human rights, and I want to say a little bit about what that is and hope that in the discussion I can understand better why one would want to move away from that. So I take it there's a starting point that's plausible in approaching the question of human rights, which is to think, well, human beings have moral rights that hold independently of any existing political institutions. So there are moral rights that we have. And then the question is, since it seems plausible to say that human rights exist independently of any political institution, which subset of moral rights should we identify as being human rights? And I take it that the disagreement between the political and the non-political conception is about what the subset is. primarily. Here we encounter right away a methodological question, which is to what extent should we privilege fidelity to actual human rights practice and go for a bottom-up approach to the question. So how much should we look at actual documents in which human rights are laid out, how they're used in political discourse, or how the idea gets used in political discourse, and so on. So that's one possibility. The other possibility is to go for a more top-down approach, where you start by asking, what philosophically should we want human rights to do? And then to develop a conception based on that, and maybe to draw out a list based on the answer we give to that question. My sense of the literature on human rights, and again, I don't know it that well, but I have a sense that the recent trend is that people don't want to be seen as doing the second thing. They want to be seen as being in touch with the actual practice of human rights lawyers and human rights conventions and all that. And I can certainly see the attraction of that, especially if you're an academic philosopher, then you're constantly told that you're out of touch with reality, that you don't really know how things go on. So it's nice if you have a little bit of street cred. But the worry I have is that if you go in that direction, then it becomes hard to see why human rights matter as a category. And what I mean by this is, so given the kind of things that appear on the list of human rights, they're always going to matter as individual rights. Nobody doubts that the right to be free from torture is very important. But the question is there something about the category of human rights that's significant? And so what I want to do in these brief remarks is to suggest how I understand what the political conceptions suggest about what's significant about human rights. And to raise the question, is there anything to be said on the non-political conception that would be of comparable, that would be as satisfying from a philosophical point of view? So let me say a little bit about how I understand how one gets oneself to endorse something like the political conception. And just not to, there's always the question, how much is it about the label, right? So the idea would be, I think the political conception helps us to identify a subset of moral rights that have an obvious importance as a subset. We can say, oh, they all have this property in common. And then the question is going to be, is there a similar property of human rights understood more broadly that's important? So how does one get to something like the political conception of human rights? Well, I take it you start from the thought that the state has a certain kind of authority with regards to the people living on its territory. It has the right to arbitrate certain disputes of right, it has the right to make various decisions regarding political matters, and so on and so forth. Now, this authority is very far-reaching, and it's far-reaching in at least two ways. One is that the authority of the state exerts a determining, shaping influence on the world we live in, right? This is sort of the familiar point from Rawls's claims about the basic structure having pervasive influence. The state sets up how the economic structure is, how the legal system is going to be, and so on and so forth. These things have a great influence on the lives of human beings. So the authority is far-reaching in the kind of influence it has. But it's also far-reaching in a second way, which I think is very important here. Namely, that the state's authority is exceptionally robust in the face of error. What I mean by that is the state doesn't always act justly. It often takes decisions that it shouldn't take in matters of right. But so long as it's acting within certain boundaries, so long as it's acting in good faith, or so long as it can be seen as acting in good faith, its decisions remain legitimate. And so one idea you might have is, well, if there's a certain subset of moral rights that all share the property of setting strict boundaries on what the state can legitimately do, something that I take it moral rights in general don't do in a strict way. Or perhaps, to put it differently, moral rights whose violations provided conclusive reason to think that the state can't be acting in good faith. That would be quite significant. That subset would be a subset worth investigating. And I think the subset is particularly important because, so I said that the state's authority is robust in the face of error. And I want to stress this is this is quite a remarkable fact about the state. So the fact that authorities in general are to be obeyed even when they're mistaken is a general fact about authority. We learned that notably from Joseph Raz in his famous discussion of authority. He tells us, I'm quoting, "There is no point in having authorities unless their determinations are binding, even if mistaken, though some mistakes may disqualify them," of course. So what I take to be remarkable about the state isn't that its authority is robust in the face of error, but it's just how robust it is, how wrong it can go before its authority is undermined. And here you may compare the case of parents and children, say. So parents have authority over their children, and they don't always make good decisions, and sometimes they can make quite bad decisions. If their decisions get to be sufficiently bad, then their authority will be undermined. And this will mean that another authority gets to step in, usually the state. Now, the state's authority is more robust than that because it really takes a lot for another authority to have the legitimacy to step in. So I don't just mean like empirically other authorities don't step in, but I think our best theories of the state suggest that if you have a good state in place, if you have a legitimate state in place, it really takes a lot for the legitimate recourse to go through something else. So if the Canadian state does something that is unjust towards you, your recourse will be through various branches of the Canadian state itself. You don't go to an outside authority. And I think one of the great fundamental questions of political philosophy is, why is the state like that? And here, I mean, there are various theories, of course. So one kind of theory that people have put forward is, well, the state has this special function. What the state does for us, among other things, is to ensure that we have determinate and enforceable rights against one another. So here you have stories about how if we didn't have the state, then our rights wouldn't be determinate. In the state of nature, you can't really know which rights you have. You can't really know how to acquire property, and so on and so forth. And then there'd be a problem of enforcement, because in the state of nature, it's not obvious at all who has the legitimacy to enforce rights. So one of the functions of the state, and maybe its primary function, is to try to solve these kinds of problems. And it seems that it can only do so if, in general, it's the ultimate authority about matters of rights. Now, how you tell the story here isn't what matters most for our present purposes. But the thought is, it seems to be important given the way we understand the state, that with respect to most rights, the state is the ultimate arbitrator. Of course, this isn't true with respect to all rights. There are basic rights that the state can't violate without jeopardizing its authority. These are usually very fundamental rights. They're usually fairly general. So an example of how these rights tend to be general is most of us think that you can set up a system of property rights in all sorts of different ways. And we think some of them are better than others, some of them are more just than others, but we think these are all legitimate ways to do it. But a state that didn't allow people to own property at all would seem to be deeply problematic. If a state took away the right to hold property in general, then that would seem to be a problem. So the suggestion I would make is, what's compelling to me about the political conception is that within this way of understanding the state's role, it gives human rights a very clear, distinctive mark. Human rights are a certain subset of moral rights, and these moral rights have the property that they limit the state's authority in a strict sense. Now, what this entails exactly, obviously, is something that different theorists disagree about. Some of them are a little bit quick to talk about the right to intervention or something like that, and that's probably not a good idea, because military intervention is very hard to justify, even prima facie, I would think. But the thought that human rights set limits on the state's authority could suggest that people's obligation to obey no longer obtains when the state violates human rights, that certain measures of resistance taken internally are justified that otherwise would be, and so on and so forth. So it can entail all sorts of things, even if it doesn't entail a right of intervention. In any case, what I mainly want to say is this seems to be a fairly big deal from a theoretical point of view, that certain rights have that property. I mean, what that does essentially is it calls into question the Westphalian conception of sovereignty that was so dominant for so long. So that's something worth writing home about. And it also explains why human rights, or that subset of moral rights, would be a big deal practically, because states play a very big role in our lives. Their authority is very extensive, and figuring out what restricts that authority in a strict way matters a lot. It's a very important endeavor. So the main question I want to raise in this slightly long-winded way is, what's the payoff to the other conception? If we understand human rights more broadly, as Professor Tasioulas and others have suggested, then I'm not sure what unifies the category of human rights anymore. Now, one suggestion that Professor Tasioulas makes in another paper than the one he presented yesterday is that we could just make a distinction between a longer list of human rights and basic human rights, which would be the ones related to state legitimacy. But then the question is, so what's special about human rights in general? What's special about basic human rights is quite clear. They play a very distinct role in political philosophy, but it seems that the significance of the category of human rights, more broadly construed, is mostly sociological. That's what people talk about in political debates. That's what pushes the progressive agenda forward and all that. And those are all very important things, but philosophically, it doesn't really mark a significant distinction. One quick remark about a point that was raised in the paper yesterday about the viability of the political conception. Professor Tasioulas pointed out that it's not incoherent when an anarchist invokes human rights, and that may cause trouble for the political conception. But I'm not sure that it does. I think the way to look at it is, once you have your conception of human rights in place, suppose you have the political conception, then you need to ask which moral rights actually fit the bill, which moral rights are part of this subset. One possibility, if you're called Thomas Hobbes, for instance, is you'll think there are no rights in that subset. No moral rights strictly restrict the authority of the state. And then another possibility at the other end of the spectrum is you may think that these human rights are so extensive that no agent could possibly be a legitimate state. No agent could do the kinds of things that we think states do and still be legitimate. And that, I take it, is the anarchist position. Let me raise a different point very briefly. And this one it's much more tentative, and it's really, I'm trying to understand the interest-based approach of rights from the inside. And one question that arose to me as I was trying to do that is there's a focus in the approach on universal interests. And I was wondering why it would matter on an interest-based approach that the interests that human rights protect be universal. I mean, if what we care about is how important they are, then shouldn't we be open to the possibility that idiosyncratic interests are very important? So I'm wondering, is there a principled reason why an interest's, to quote Professor Tasioulas, duty-generative capacity would depend on its being idiosyncratic or not? So I would think it can't be based on importance, because, a pianist's interest in having access to a piano will be an incredibly important interest, and we all share interests that are comparatively unimportant. It could be a concern about institutionalization, of course. If you're planning to institutionalize these moral rights, then it's going to be a lot easier if they apply to everybody. Otherwise, you have to tailor them, and that's going to be hard to do. And there'll be worries about equality and people having expensive interests, and so on and so forth. But if human rights are just to be thought of as purely moral rights, in the way that I think Professor Tasioulas suggests, then I'm not sure why they wouldn't be tailored in this way. Now, of course, there's something epistemically significant about universal interests. It's easier to know that people have them, and so it's easier to plan accordingly and to act accordingly. And I'm wondering, is this what's doing the work here? That it would be burdensome if our moral system included idiosyncratic rights. But I'm not sure that that captures the significance of human rights. I mean, when we talk about human rights, I think we assume they're not just special because they're easy to identify. Now, one possibility would be to say universality itself makes them special because it's an affirmation of the equal standing of all human beings. But then I'm not sure how that fits with the idea that equal standing is a precondition, as it is on Professor Tasioulas' view, and that it's the interests that give rise to the various rights. But I've already gone over a little bit, so I'll stop here.
Okay, let me just respond quickly to those very thoughtful comments. I think the difference between someone like myself and people who run the political line has got something to do with this issue of fidelity, whether the existing human rights practice exerts any kind of constraint on how one theorizes about human rights. And of course, there could be many different projects that come under the heading of philosophy of human rights. The project that I am engaged in is one that wants to take that practice seriously. Now, I'm sure Louis-Philippe, in a kind of half in jest, said, well, this is a crass desire for street cred on the part of philosophers. But there's another way of looking at it. And the way of looking at it is to say, well, this human rights movement seems to be something very powerful. A lot of very intelligent people are engaged with it, further it. It seems to be doing a lot of good. Rather than begin with a prior commitment to some philosophical viewpoint, why not begin with the movement, what it's doing, and see what sense we can make of it? That's one kind of legitimate project. And you might discover that there's no sense to be made of it, that it's really just a diversity of people with contending political views using the slogan human rights as a way of furthering their particular political agenda. But you might find that if you reflect upon it charitably, trying to make the most sense of it, there is some kind of underlying ethical idea to be discerned there. So my claim is, that's my project. I'm not starting off with some very specific commitment to consequentialism or any political liberalism in roles and sense. My project is a kind of bottom-up project. And I actually think, one, that's intellectually legitimate. There's also another aspect. I sometimes think to myself, how did Rawls sleep at night? Coming up with a theory of human rights, where the vast majority of human rights recognized by the movement isn't acknowledged. He calls them human rights. He says, no, these rights, free speech, equal freedom of religion, non-discrimination on grounds of sex, are not really human rights. They're merely liberal aspirations. I think philosophers ought to be canny enough to understand that when they make moves like that, it has potential political implications. It means that right-wing critics of human rights, for example, can turn around and say, look here, the leading liberal political philosopher of the last 100 years does not believe there is a human right to an adequate standard of living. I don't think it's merely words. I think these sorts of decisions have serious political implications. And I think it's not unusual to find that many of Rawls's most devoted followers actually regard his theory of human rights as, in a sense, a kind of sellout of his liberal principles. But I start in a different place. I start from this idea that we should take, it's a kind of conservative, small c methodological principle, we should take the practice seriously and see if we can make any sense of it. And if we can't, then it might be a matter of philosophers coming in and salvaging the concept through some sort of top-down rehabilitation exercise. If you engage in this project, the question is, what sense am I finding in the notion of a human right? What draws it all together? And my claim was, not that human rights are all moral rights. Of course, there are moral rights that are not human rights. I might have some moral rights because I'm a member of a certain university. I have a moral right to be treated in a certain way or to have access to certain resources because I'm a member of that university. But human rights are a subset of moral rights. What unifies them? They're rights possessed by all human beings simply in virtue of their humanity. That's what I think unifies them. I think that's a sufficient answer to the question, what unifies them? Now, of course, we can engage in further discussions. We can say, well, some of these rights have further important political roles to play, or are distinctive in further ways. But my view is the most all-encompassing and satisfying account of human rights is the one that historically ties it to the natural rights tradition. And that's the understanding of natural rights in that tradition. Moral rights possessed by all human beings simply in virtue of their humanity. And I think explains why the list of human rights that we find in standard human rights documents is actually far more expansive than the list of human rights that a lot of the so-called political theorists come up with. So that's how I would answer the challenge. But then I would also think that there are some difficulties with the political view as well. I mean, you began by saying we all accept there's this general category of moral rights and human rights are a subset of that category. In fact, it's a feature of the political view that a lot of people don't accept that position. So Charles Bates, for example, is one of the most important proponents of the political view, is agnostic at best about whether there's an informative general category called moral rights, of which human rights are a subset. He wants to say, no, human rights are sui generis. That's how we should think of them. Don't think that there's some ethical concept in the background called a moral right, and that within this you can narrow it down to human rights. Rawls maybe is different. Rawls might have more of the subset sort of view. So it's not even clear on the political view. I mean, some people are so radically political, they say, look, it performs a distinctive political role, don't even think of it as a subset of something that's more abstractly moral. But let's go to the concrete thought that was put forward. The idea was, well, look, human rights are bound up with the state. And straight away I find that problematic, right? I need to understand what the state is to understand what human rights are. The anarchist rejects the state on the basis of human rights. I'm not sure I understood the response you're making about the anarchist. Maybe we can come back to that. But I need to understand what the state is. And I need to know something else as well, I think, that the state has authority. But do all states have authority? Just in virtue of being a state? Or only nice states like Canada? I wasn't sure what the implication was. One would need then not just an account of the state, and notice Rawls doesn't buy into that. Rawls doesn't relate the notion of human rights to states. In fact, he rejects the notion of states in developing his law of peoples. He talks about peoples because he thinks the notion of a state is tied to certain claims of sovereignty, both internal and external, which can't be sustained on his view. So he would give up the notion of a state. But other people, like Chuck Bates, do work with the notion of a state. So we've got the notion of a state in place and the notion that the state has authority. Well, perhaps not every state has authority. Some states have authority. But then the thought is human rights are those rights which, if violated, defeat the authority of the state. So the state's normal claim to the obedience of its subjects is defeated when, well, at least in the case when human rights are violated. Has that helped me identify human rights? Don't I need a theory of authority to know which rights are those rights, the violation of which defeats the authority of the state? But I didn't hear the theory of authority. So I'm not anywhere further forward in understanding what human rights are unless I now, in addition to having a concept of moral rights, have a theory of authority. And then I'm able to identify within that theory of authority which rights defeat the authority of the state. And the implication was maybe very few. So there might be just a couple of rights, like right not to be tortured, right not to be killed, right to private property, a small number of rights. Okay, and then the question is this, on my view. Why mortgage the notion of human rights to that potentially vanishingly small number of rights? Why not say there's a subset of human rights which have this particular role of tripping up the authority of the state, but recognize that in general moral discourse, human rights perform many more functions than the function of being the last straw beyond which, at that point, the state ceases to have authority. So that would be both my defense of the orthodox view as I think of it, and the problems that I would have with the political view, then you also raise the point about why universal interests. And the reason, and I think this is a difficult point, but my response would be this. I wasn't giving, and it may have been a defect in my presentation yesterday, I wasn't giving a theory of moral rights in general. I don't think that moral rights in general are human rights. I think human rights are a subset of moral rights, which once those moral rights possessed by all human beings simply in virtue of their humanity. So it's definitive of human rights that they're universal. But where do they get their universality from? My simple-minded thought was from the universality of the interests. Everyone has them because everyone has the interests they serve. And of course, there might be some rights that you have if you're especially gifted. You might have particular rights to certain resources against the state, but you wouldn't necessarily have that as a human right. You would have that as an unusual, particularly gifted person. There might be some women's rights that aren't strictly speaking human rights, but they'd be rights possessed by women as women. It doesn't make them inferior or superior to human rights. They're just a different category of moral rights. But, you know, the right to bear children is probably not a right of men, but it's perfectly intelligible as a right of women. It's not a human right, not possessed by all human beings simply in virtue of their humanity. There's a very funny Monty Python sketch about why this can't be a right of men. So that's the thought. The thought is, if they're going to be universal rights, they must find a hinge in something that's equally universal, the interests that they protect.
Thanks.
So let me begin, like Louis-Philippe, by thanking John for a very interesting paper from which I learned something about the current philosophical discourse on human rights, about which, like Louis-Philippe, I'm a bit kind of out of touch, and so it was very useful, and I think, like Louis-Philippe, I'm more tempted towards the political conception, but we kind of decided to divide the labor, and the way I'm going to proceed is by raising some questions about that are kind of more internal to your project, and questions that I had while reading it. And I know that this paper, in some respects, is part of a larger project. So I'm not necessarily saying that you don't have an answer to them elsewhere. It's just thoughts or questions that I had while reading it, and I'll be happy to hear your further thoughts about them. So the starting point of John's position is that rights are grounded in interests that are particularly important to give rise to duties, and then in the paper he says, well, how do we know which interests are the ones that give rise to duties? And he says, well, that's the limit that philosophy can get us. But he says there's more that I can say, which is the constraints. Well, we'll see in a second to what extent there are constraints, but he mentions two threshold requirements. But as I see it, even at this stage, at the sort of philosophical, general, abstract level of discussion, there is a potential challenge that may say not that the question will be not which particular interests give rise to duties, but rather the suggestion that interests never by themselves give rise to duties. And so the question that is sufficiently abstract and sufficiently general is to say, what is it about any interest that could give rise to a particular duty? And this challenge may come, at least in this particular context, not just from a moral skeptic who just says, well, I can do whatever I want, but also from someone who has a more political conception of rights, of human rights. That is to say that that they may try to base some kind of argument about rights the protection of human rights exactly on the existence of a particular political community that gives rise to certain, that can give rise to certain duties. And in particular, you say at one point, it is not just reason or even more reason, but a specific kind of more reason that suffices to impose duties. It is categorical in that it applies to us independently of how we happen to be motivated. And this, at least on some views, cannot exist without a certain institutional arrangement. Now, I don't say by this necessarily a political arrangement, but at least a certain existence of certain institutions. For example, the institution of promising. And in the context of human rights, perhaps the institutions that need to exist in order to give rise to those duties are more robust political institutions. And a particular danger, I think, for an account like John's, is that the answer to this question, what particular interest gives rise to duties, is going to sound consequentialist. That is, the ones that make life better or life possible. And I suspect that this is actually where dignity comes in some respect, in some way in your story. That dignity could play a role in this account by telling us that it is not a consequential reason that explains why certain interest gives rise to duties, but rather something like dignity. But then I suspect your story may not be as different from the Nagel or Francis Cam's story that you thought to distinguish yourself from, but I'll get to this perhaps in a second. But now I want to move to talk about the thresholds, and in particular about the feasibility, about which I thought I think I have a little bit more to say than about the other. And the feasibility threshold could be understood in two ways. One is a constraint, and the other is perhaps a positive component that could give ground to human rights. That is, when certain... So on the first conception, feasibility can only limit the sort of interest that can give rise to rights, and on the other, perhaps it can also give a positive reason to protect certain interests as right when the state, for example, or when we have certain resources for doing so. Now, why is this distinction important? So I want to now consider the two ways of thinking about the feasibility. One, first as a positive component, and the other as a constraint. I should say, however, before I get there, perhaps that one reason why you might want to think about this not merely as a constraint is because if you think about this in this positive way, then you have some kind of story to tell us that at the most abstract level with regard to the question of how we move from interest to duties. Now, if feasibility is not merely a constraint for imposing rights, but also a positive requirement for recognizing rights, then one gets a very important addition to John's account that I think has one interesting advantage. It can answer a serious potential challenge to the orthodox view, which is, why is it that rights discourse appeared on the scene right now? At least with the intensity that it has appeared in the last 30 or 40 years. So it's true, I guess, that Tierney's account, of which I know very little, can draw certain links between contemporary human rights discourse and medieval discourse. But it is also true that the way in which people talk about human rights today is very different from how they talked about this even 60 years ago. And this is something that comes up in Moyne's book quite clearly. And so if you think of the feasibility as a positive element, then you have something else to say. Well, the world today is much richer, or at least the Western developed countries where this discourse was born in, have the resources to start talking about human rights in this way. And there is the book of the economist Friedman, not Milton Friedman, but I forgot his first name, The Moral Consequences of Economic Growth, which talks exactly about the fact that economic growth, the wealth of rich countries, have allowed them to start expanding their moral worldview. Now, this may sound like something that John would be happy to adopt, but the problem is that then it may be the focus on interests and the idea that human rights are grounded in interests that individuals, that humans have, may become secondary, because then we may be very quickly moving to something that sounds very much like the political view, or perhaps even worse, economists talk about simply weighing of costs and benefits. So here's a sort of dilemma that I pose to John. Without a positive account of feasibility, the account has difficulty explaining certain historical features of the human rights discourse that John wants, and we heard it now more than even yesterday, that he wants to join or understand. But with them, the central element of rights being grounded in individuals, and individuals' interests seem to be kind of moving backwards. Now let's go and talk about feasibility, assuming it is only a constraint, merely a constraint on the question of what interests become rights. So suppose we consider a certain interest important enough to be the subject of a right. How can it be then that it can fail to impose a duty unless it violates the rights of the potential duty bearer? So if it does not violate the right of the duty bearer, then it looks as though the right holder's sufficiently important interests are slaves to non-sufficiently important interests of someone else. And then we seem to have a difficulty in the account that human rights of certain people are outweighed by considerations that themselves are not right. And I have a quote here, the interests. Yes. And indeed, you said at one point, the interest-based theorist has an answer to this question, the question of what is distinctive about human rights, and that is that it is the part of morality that concerns rights has a distinctive kind of justification. The interest of the right holder suffice without the benefit of the additional weight of others' interests to generate duties. But of course, this is difficult if we say that interests of particular right holders may be outweighed or set aside for non-rights of duty bearers. If, on the other hand, sufficiently important interests can only go unprotected, that is, not right protected, if they're conflict with sufficiently important interests of potential duty holders, then this seems to alter completely the picture of what rights we have, because rights then are not, as promised, focused on the right holder, but rather on some reciprocal balancing of what people owe to each other. And then perhaps game theory or something like game theory rather than human interest seem to be more important to determining what rights people have. Okay, I'll skip. I have some discussion about Nagel, whose paper I got to read as a result of yours, but I'll skip that. Perhaps we can talk about this later. But I want to talk now about human dignity, which towards the end of the paper you set as the central aspect or the central foundation of your account. And you admit that the danger with regard to human dignity is that it's this kind of feel-good, to use your expression, this kind of pleasant-sounding rhetoric that is who can be against human dignity, but then it's difficult once you look more closely into it. And I understood your discussion to be an attempt to say, well, we can have a fairly precise understanding of what human dignity is that can give us sufficient grounding and not be just empty, pleasant-sounding rhetoric. But I actually want to ask a few questions about that. some of which actually comes from actual legal practice. So I'll tell you a story about Israel, which is where I come from. So in Israel, there was a big debate about in the early 90s about which rights to put in a kind of, there's no constitution in Israel, but something like the beginnings of a constitution. And there was a lot of disagreement about rights. And in the end, there was agreement on very few rights, among them human dignity, because people said, who can oppose human dignity, right? I mean, we can disagree. There was opposition to constitutional protection of freedom of speech. Why? Because certain parties were afraid that the Supreme Court, that they felt was very liberal, is going to offer a particular interpretation of freedom of speech, for example, that they would find disagreeable. But human dignity managed to go through. And of course, what happened then? The Supreme Court started interpreting human dignity, and then people started getting worried. Oh, the Supreme Court interprets the idea of human dignity in a particular liberal way. So, for example, there were debates. Does violation of freedom of speech, or does limitation of someone's speech, including hate speech, including racist speech, does this constitute a violation of human dignity? So we seem to have some kind of a problem in this, in kind of moving ourselves from the general concept of human dignity to actual precise understanding of what it is. And perhaps this is something that you explore more elsewhere. I'd be happy to hear if you have more to say about this. In the same context, I should say, or another example, there's work of comparative lawyer James Whitman on the different understandings of human dignity in the Anglo-Saxon world as opposed to dignity in German and French law. And there he says, for example, insults are the basis for legal claims in Germany, much more than claims that strike people in the United States, and I would imagine also in England, by the way, without a First Amendment, as preposterous, are valid, successful, potentially successful legal claims. Calling someone an idiot on the street may get you in court. So the worry with regard to dignity is something that I think I would want to hear a little bit more about. And I'll finish with another, my last point right now with regard to dignity is perhaps your limitation of the discussion to human beings. So your defense of human dignity, and I quote, is there is a meaningful notion of human dignity. This is a notion of an intrinsically valuable status rather than one human interest among others. It characteristically operates in intimate union with universal interests in grounding human rights norms, and there is a stress about the human there, which is perhaps not surprising when talking about human rights. But perhaps here is a different kind of parochialism that may be in context, and the one that I have in particular is primates. And I've been reading Frans de Waal's, and he's a famous primatologist who has now thought that he could extend his ideas from working with chimps to human beings. And one of the striking things you read in those discussions is how, well, human-like chimps are in many of their behaviors. So here's a particular example. Would you think that primates, chimps, can claim a primate right not to be experimented on the basis of something like human dignity? So.
Maybe a few moments.
Okay. That's very interesting and complex and diverse thoughts. Let me begin by discussing the human dignity first. I think human dignity is important. I don't think by itself it's a self-sufficient basis for deriving human rights. So it has to work, as you said, quoted as saying intimate union with interests, and of course it's not a magic bullet. Like any moral concept, it's going to be liable to many different interpretations. Maybe some of these will be permissibly different interpretations, no doubt will be subject to erroneous interpretations. That's just the fate of any ethical concept. But my notion of human dignity is the intrinsic value that attaches to being a being of a certain sort, a human being, with the characteristic powers, potentialities of human beings. This is perfectly compatible with there being primate dignity, the dignity that comes with being a primate or an ape of a certain sort. The Israeli Supreme Court had a decision about the dignity of a crocodile when it said it was unlawful to engage in man-crocodile wrestling. It makes perfect sense to me. There is a dignity of a crocodile, the intrinsic value accruing to being a crocodile, and merits a certain kind of respect. So I don't think, that's why it's human dignity. Human there is not redundant, right? It's the dignity, the intrinsic value that comes with being a being of a certain sort, and there is also an intrinsic value in being a crocodile, in being an ape, and provided the argument with interests can work in the case of crocodiles and apes, and I'm sure it can to some degree, there will also be rights on the part of those beings. I'm perfectly relaxed about that. Because if you have an interest-based account, what you're saying is there is some kind of being of ultimate value, and the dignity picks out the fact that it has this ultimate value, whose interests are sufficient to impose duties. Now, the content of the duties will be very different. I don't suppose crocodiles will have a right to vote or political participation, but they may have a right not to be tortured, for example. That's broadly comparable to humans' rights not to be tortured. I find this perfectly fine. In fact, I think it's a kind of positive feature of the interest-based account, that it can make sense of the fact that people have been drawn to talk about animal rights without thinking of animals as some sort of players in a political institution, without thinking of animals as necessarily having any kind of developed capacity for autonomous decision-making. No, they've got a dignity that inheres in the nature they possess, and they have certain interests, the fulfillment or frustration of which makes their lives go better or worse. Though I agree with you, much more needs to be said about dignity, and much more needs to be said along the lines of it's not just a kind of pathetic hand-waving attempt to say, just because I've got interests, I'm not a consequentialist, or just because I'm appealing to interests. Now, you made also, Dan, some really interesting but complex points as well about feasibility. And one of them was, well, perhaps we can think of it more as a ground, a positive ground than a constraint. I mean, I wasn't sure I was grasping that distinction, because in a way, one way of looking at it is, well, it's a constraint when it doesn't allow an argument to progress from an interest to a right, but it's a positive ground when this is the threshold is passed, and you can say, okay, it's past this threshold, this is what makes it a right. I thought, I mean, as you suspected, I would want to take on board some of the things that you said. So I would want to say, I don't want to say that rights have become particularly prominent now and never were at any time before in history, but there is a kind of proliferation of rights claims. And part of it might be things that were not formally feasible are now feasible. You know, does it make sense to say that, if you think about reproductive rights at a certain point in history may have been, well, you know, people shouldn't be castrated. They shouldn't be compulsorily sterilized, a whole bunch of negative duties. But with the development of technological capacities, you might have a situation where eventually people have rights to positive assistance to reproduce, which they didn't have before. Why? Because before either it just wasn't possible or it would have been massively costly to make this something available for each person. Now it's no longer the case. So I would regard this as a way of, again, making sense of proliferation in a benign sense. If people have this notion that certain things are feasible because of technological advance which formerly weren't. Of course, it can work the other way. It could be that developments like climate change mean that in future some of the rights we think are unproblematic now, like a right to an adequate standard of living, might no longer be feasible. Maybe then we can only talk about a right to subsistence and not an adequate standard of living. One other point, just quickly. Now you made this interesting point that there's a problem with feasibility, that how can people's rights turn on costs for other people which are not costs to their rights? Doesn't that land you in a strange kind of consequentialism? But I'm not sure, because think about this. Say people have a right to, I don't know, not be depressed, let's say, or an interest in not being depressed. And you wonder, well, do they have a right not to be depressed? In particular, do they have a right to the provision of a certain medication that will ensure that they're not going to be depressed? The trouble is, this medication, the only way to get it is by getting some substance that's inside whales. But you've got to get it by killing them when they're 6 months old. And so the thought would be, in order to deal with this issue of depression, the cost would be basically a massive culling of whales at 6 months old. Now, it's not clear to me why that kind of assessment is ruled out, why I can't say no. Because remember, it's question-begging to say he already has a right to depression, and now I'm undermining it by reference to the interests of the whale. I'm trying to find out whether he has a right in the first place to be provided with this medication. And part of what's going on in deciding whether they have a right in the first place is, well, what are the implications? What are the costs? And amongst the costs you would have to factor in, I think, are costs. And I don't want to say at this point, I mean, you might think whales have a right to life. But you might, the example doesn't turn on this. You might just say, this is a particular cost being borne by another being, and the interest isn't sufficient to impose a duty on others to provide this particular service to the right holder, putative right holder, because of the cost that's involved. But the general point is, we're trying to figure out whether these rights exist in the first place. We can't assume that they exist and then say, oh, but these costs defeat them. But of course, there will be some costs that will defeat rights that exist anyway. Most people are going to buy into that, even Nagel, unless you have a kind of across-the-board absolutist view of rights. But I think I'll stop there.
Okay. Thank you very much. So we now have time for questions. I would ask, though, that can I move that one here? Just to wait for a microphone.
You were saying earlier about how dignity can attach to beings of a different sort. So, there can be a different kind of dignity for humans, a different kind of dignity for chimpanzees, etc. How do you suggest identifying what kinds of dignity exist for these species, and what kinds of interests or rights follow from that specific kind of dignity for each group of beings, whether sentient or not?
Well, that's a tough question. Think about the case of human beings. So what you would have to think about is, what are the distinctive features of being a human being that give us a certain kind of value, as having intrinsic value? So we matter as beings in our own right, our life matters in its own right, and our fulfillment of our interest matters in its own right. What are the considerations you would take into account? And so presumably you would take into account things like, obviously, capacity for reasoning, capacity for forming various forms of attachment, language use, and so forth. These are distinctive features of human life, and they're a kind of locus of value. It's something that we ought to respect and value. That's roughly the intuitive thought. But my thought then is beyond that. Presume that's something we could agree about. We would have to make the further step. So beings of this sort then, who merit a certain kind of respect, we now progress to the second question: what makes their life go better or worse? And their life being able to go better or worse partly depends upon what sort of beings they are. So for human beings, it's a tough question, but for human beings, I'm attracted to sort of what are broadly known as objective list theories of the good. you would say things like, well, there's things like enjoyment and freedom from pain, but there are also things like acquiring an understanding of the environment, being able to act autonomously, being able to form some kind of friendship, community with others, achieving something with one's life, engaging in play. We work out a conception for human beings in that way and test it to see whether in fact this is just parochial or whether we have particularly parochial understandings of universal value. So you might think, okay, achievement is a universal interest, but it's a parochial understanding of achievement to think that it's primarily through employment that one achieves in life. There might be, if we're thinking cross-culturally, there might be other ways of understanding what achievement involves. Now the thought would be, why couldn't you do that same process for other sorts of beings? It's harder because we're not beings of that sort, and maybe we're using as a platform our own conception of well-being, but there might be some common ground there in terms of things like certainly avoidance of pain and some forms of enjoyment, some forms of play, etc., some forms of family life. So imagine people who do experiments on animals, keep them in isolation, etc. You might say, again, there are all sorts of indicia like depression, etc., which tell you that the life of that being is going worse by being kept in isolation because they're strongly communal animals, etc. So I think of this not as a kind of top-down structure. It's very much bottom-up. It's looking at the facts of the particular sort of being in question. What sort of being is it? And what kind of interests does it have? And then progressing to the question, the threshold test. When are these particular interests sufficient to impose a duty? So the general schema that I outlined, I think, partly because it's vague and unspecific, could be applied also to beings other than human beings. But I think there is a legitimate distinctive interest in talking about human rights because humans constitute a distinctive kind of being and have distinctive sorts of capacities that in a sense rank us higher than other animals.
John, I take it one of the central ideas of human rights is that they're, in some important respect, context independent. And you capture this by saying, well, they're held by all human beings, regardless of various other facts about them. That they are grounded in an interest which all human beings have. They're universal in that sense. But then, when the claim is that you have the human right if the interest is sufficient to warrant the duty, and you bring in the threshold conditions that you've mentioned, say particularly the one that you were talking about in answer to Danny, and your depression example, for example, comes to mind. I wonder now whether human rights become context sensitive. They're not the kind of thing that we have simply in virtue of our humanity, because it'll depend on a whole slew of other conditions which will factor into determining whether in fact in that particular context, say in that state or that community, the interest will in fact be sufficient to generate the duties.
I'm really glad you asked that question because I think it's a defect maybe in the presentation that I gave that I didn't mention. The way in which human rights can be universal and context dependent. One of the reasons people who are political theorists reject the natural rights approach to human rights is they say, well, look, as a political theorist, I'm trying to be faithful to the human rights movement. And the human rights movement talks about a whole bunch of rights which surely could not possibly be thought of as possessed by all human beings throughout human history. I mean, does it make sense to say that cavemen had a right to citizenship or political participation? So if you were really talking about natural rights, you would have to limit yourself to very, very, very small set of rights, like right not to be tortured, for example. And that's not what the human rights movement is about. So Chuck Bites, in one of his earlier pieces called What Human Rights Means, made this quite central to his rejection of seeing the human rights movement in terms of the natural rights tradition. But that is a certain understanding of natural rights. That understanding of natural rights interprets natural in the phrase natural rights as meaning could be possessed even in a state of nature. So these are rights that throughout human history apply, because even in a state of nature, even without political institutions, without any technology, without any kind of state structure, you'd have these rights. And my view is, look, you can talk about those as human rights, but you've got to specify the context in which you're talking about. So you might say, when I talk about possessed by all human beings, I mean all human beings throughout human history. But I think in the case of the human rights movement today, there is an implicit temporal constraint. So the idea is, we're talking about all human beings in roughly modern conditions. And I think that's a perfectly legitimate move. And one of the interesting things about Tierney's argument is he says this is a feature of the natural rights thinking itself. People who were natural rights theorists were not thinking, oh, but this won't be a right unless it's possessed by all people throughout human history. I mean, the mind boggles to think about how you would engage in that kind of thought experiment. And being able then to say, of course, you can talk about human rights possessed throughout human history, but you can also specify, no, I'm talking about rights possessed by people in broadly modern circumstances. That then gives you more content to address issues of feasibility, because now at least I've got some kind of more concrete sense of the obstacles or possibilities for serving interests than otherwise would be the case. So that would be my response, that you can retain universality within a temporal framework, a constrained temporal framework. And the second point is, I mean, I think that's certainly how the people who were drafting the Universal Declaration of Human Rights were thinking about what they were doing. They weren't engaging in thought experiments about, does it make sense to attribute these rights to Stone Age cavemen? But I also think that the natural rights tradition, only one component of it identified natural rights with rights possessed in a state of nature, the Lockean component, if you like, Lockean, Hobbesian. But there were other prior natural rights theorists who didn't have this conception.
I take it temporal differences are only one element of the different contexts. Presumably, you got a whole range of other things. So, for example, what's viable in, say, Canada or Britain may be very different from what's viable somewhere in the jungles of South America, for example.
Good. And I think at this point, you might say I'm making an arbitrary cutoff point, but I wouldn't allow those sorts of variations in a theory of human rights. So I would say synchronically they're universal, but not necessarily diachronically. Right? So if you're really talking about human rights, you're talking about rights, and I just take this to try to be faithful to the discourse as I see it. They're rights possessed by all human beings who inhabit a certain kind of period of time. Now, it's also possible to say, as a Canadian, I might have rights over and above human rights. I have these rights because I'm a member of a certain political community that has certain sorts of resources. And so maybe as a human right, I have a right to subsistence. But maybe as a member of the Canadian political community, I've got a right to much more than subsistence. And I think it's a virtue of this account that it doesn't rule that out. Human rights are not all the rights that there are. There are certain other rights that we have not simply because we're human, but rights that we have out of political membership. And that's a different set of rights. And they don't all have to be seen as somehow flowing from background human rights. They could flow from interests one has as a member of a political community.
Okay, I had a couple of questions, but I'll start with one. And this is partly a question to sort of understand your view a bit better. And in particular, I wanted to understand a bit better the relationship between interests, rights, and duties. And if duties and rights get generated together, or how it works, because, so I understand that you start out with these universal interests, and then I take it that typically it's understood that we need these rights to protect these universal interests. And sort of correlative with these rights, there are duties. And sometimes these duties are duties not to violate these rights, and other times they're duties to secure the conditions necessary for these particular rights. And so what I'm wondering about, maybe it's the way I set it up in terms of having interest, rights, and then duties, but I'm wondering about some duties that get generated are positive duties, some are negative duties, others are imperfect duties. And how on the interest-based account do you know which kinds of duties get generated? And I was thinking about the right to life, for example. And so then you have the right of a needy person, a hungry, starving person. And part of how we can, part of the right to life is having the conditions necessary to live and having food and basic goods. And who owes this to that particular person? Who has the duty, and what kind of duty is it? Certainly we have duties with respect to some people who are in need. We don't have duties with respect to all of them. And so I'm just wondering, how is it that the duty gets the shape that it gets on this account? And I imagine that feasibility might have some role to play here. And so that, I think at one point in response, you mentioned something like something that could have been a negative duty. If you have feasibility, then it could become a positive duty. And I imagine that some duties, like the duties to aid the needy, could be very demanding indeed. And then does that make it immediately unfeasible? And if so, does no right come about because of this? And does the threshold vary with the importance of the interest being protected? And so that, in this case, certainly it's the right to life would be probably the most important interest. So that was sort of my first kind of question.
Yeah, that's a difficult question. I mean, I don't know if I can say a lot that can satisfy you. Clearly, the threshold has to be sensitive to the strength of the interest. So the question is, does this interest suffice to impose duties on others? And whether an interest will be able to generate duties will partly depend on the strength of the interest in question. Right? That certainly must be the case. Because I want to come up with a theory that tries to make sense of the human rights movement, because I think it's legitimate to begin with a presumption that there's something correct in this movement. I don't want to rule out on a priori grounds the possibility that the duties associated with human rights can also be positive as well as negative. There would be one quick way of ruling out positive duties, and that's the way that Honor O'Neill adopts. So O'Neill's thesis is this: if human rights exist, they must generate duties, but not just duties they must generate duties independently of any institutional dimension. So pure moral reasoning can help you identify the duties generated by these interests. But not only must the duties exist, the duties must be claimable as a matter of pure moral reasoning. So by pure moral reasoning, without the help of any kind of institutional setup, I know who bears the duty and who I can claim it against. So think about the right not to be tortured. Who bears the duty not to torture me? O'Neill's answer is, by pure moral reasoning, I can answer that question. Everyone bears the duty not to torture me. I have right to adequate food. Who bears the duty to provide me with adequate food when I'm in need? Well, does everyone in a rich country have the duty to provide me with one sandwich each? Pure moral reason is not going to be able to tell you. So that kind of duty, O'Neill says, you need some kind of institutional setup in order to allocate it. And that's why it can't be a human right. Because the existence of the claimable duty doesn't follow from pure moral reasoning. It follows from pure moral reasoning plus some institutional system for allocating the duty. And what I want to say against her is that second requirement is unnecessary. That what matters is that the interest is sufficient to generate duties. Children have a right to education. That means not just the right not to be interfered with in getting an education, but a positive right, positive duties to furnish them with education. Who bears that duty? Against whom can they claim it? Answer: there are many different ways of allocating that duty. Many different feasible ways of allocating that duty. And many different societies will allocate the duty in different ways. Now, the fact that many different societies can adopt many different mechanisms for allocating the duty, the fact that there's a kind of embarrassment of riches here, should not prevent us from saying there's a human right to be provided with education. Why? Because at an abstract level, we've identified that this is a matter of duty. What we haven't been able to do at an abstract level is to pin down who exactly bears this right, this duty. But why should that be determinative of whether there's a human right? Only if you thought the whole point of human rights was basically legalistic, knowing who I can take to court, knowing who I can blame. But I don't think that human rights have to be seen entirely as part of a kind of blame culture or legalistic culture. You can say these interests generate duties in the case of all people, but what's interesting about these positive duties is typically, not always, but typically, pure moral reasoning won't tell me who I can claim it against. We need institutional setups at that point to allocate them. I don't know if that answers your question.
So I get the point about you need the institutional setups to figure out how to allocate the positive duties.
And even to specify them.
And to specify
them.
More
concretely. Yeah.
But the fact that it's positive versus negative, does that just come out on the basis of the particular interest that's at stake?
I think the same interest can generate negative and positive.
Yeah.
The same interest. So it could be clearly the right, your interest in life imposes a negative duty upon others not to take your life, but it will, for example, generate a positive duty, the most minimal one, where at tiny cost to someone, they could save your life. They fail to do that, I would say. And actually that's a case where the duty is allocated without, the positive duty is allocated without institutional mediation. If you're the only person, the other person's drowning in a 2-inch pool of water, and all you've got to do is simply lift their head out of the water, then it seems to me that without any institutional mediation, it's clear that duty is claimable against you, and it arises from his interest. Now, then the question is, well, okay, that's pretty minimal. How much further can we go? And the answer is you've got to actually engage in the reasoning. And mine's just a framework. It's not kind of some sort of magic formula that enables you to churn out answers to what human rights exist. I don't think philosophy can take the place of disagreement, but it can provide some sort of structure in terms of which we can make sense of what we're disagreeing about.
I answered your question. Okay.
A pretty good answer then, isn't it?
Thanks for presentation. The first question is, what do you mean by the state? Because apparently I do not have any rights, any dignity without the states. But a state, it's my enemy. It's really my dignity. I give 2 examples of a state crime. That is mass murder, that is the war. As professional murderers, that is military, it's the business of the state. And second crime of the state is punishment, and especially prison. For example, in the United States, the prisoner are forced to work for 12 to 40 cents per hour, and in England is for £7 a week. That it's legal. So penal slavery, when we do not have any slavery, that is the state crime. And after that, what do you mean by really by human dignity? They are not human beings? Thanks.
Well, I don't want to defend any of those policies, I have to say. And I didn't introduce talk of the state. I mean, to me, the state is a political organization that claims monopoly of the use of force over a particular territory. And nothing, it doesn't have any legitimacy as a result of that. It's a further question whether the state has legitimacy. But the mere fact that it is a state does not endow it with any legitimacy as far as I'm concerned. So we need to ask the question, okay, what directives, what laws is this state creating? And are these laws worthy of respect? But the mere fact that it's a state, for me, doesn't mean that it has any kind of moral authority at all. It means that it claims moral authority, but its claim might be entirely wrong. I mean, I don't know if you want to...
I would agree with that.
Because if I protest, I become a criminal. Against, they will punish me. Instead of they punish the state, they punish me.
Right. Well, that would be a state without much legitimacy, I suspect.
Thanks.
But in this case, if a state without legitimacy is but allocating some of these duties you mentioned, for instance, education or others, we have these cases of governments, of states, elected states. You talked about Israel, perhaps we can mention here Hamas. But they are not legitimized, but they are allocating certain of these duties you mentioned.
Good.
What then?
Okay, well, I didn't really talk about legitimacy, but I'm happy to talk about it. My view of legitimacy is this. What is legitimacy? Legitimacy is the claim, sorry, the question is legitimate authority. So what's authority? Authority is the claim, a right to rule. The state claims the right to rule you. Its directives provide you with duties. Because the state said so, you have to do it. Now, my view about legitimacy is it's not all or nothing. So you don't have to say, well, either the state's legitimate or it's illegitimate. We can talk about fragmentation of legitimacy. So it might be the case that if I'm in a particular state, am I bound by its traffic laws? Yes. Its traffic laws do bind me because I'm more likely to drive safely and not kill people if I comply with the traffic laws. But am I bound by their laws that require me to report people with suspect political views or who belong to certain religions to the police? I'm not bound by those particular laws. Why? Again, because I wouldn't be furthering my destiny as a human being, which is to comply with reason by taking the state as my guide in that particular case. That's compatible with the point that Louis-Philippe was making, that the authority of the state has to be compatible with the possibility of a great deal of error, but some errors are too grave. So my answer would be, even some of the most heinous states, parts of their law would have legitimacy. For example, the law about traffic regulation, typically, some of the law about basic criminal law, and that's perfectly compatible with vast swathes of the rest of the law having no legitimacy whatsoever.
Well, I have a question. So from yesterday's lecture, the structure of the argument was to show that dignity as a foundation for human rights can be seen or understood to play an important role by seeing just how far we can and can't get without invoking dignity. And the strategy was to look at a couple of accounts which came up short. Now, in defending the idea of human rights, what I really like about the account is that an interest-based account which is sensitive. I don't think to political conditions, because for good reason you want to avoid the political conception of human rights, but an interest-based account which is sensitive to and has an account of feasibility which is sensitive to social conditions or technological conditions or conditions even of resources. Maybe could play a role in what kinds of human interests generate human rights. And I think what's powerful about that account is that it can keep the discussion of human rights going, and it can also generate discussion about what kinds of duties some institutions, states, or research institutions might have to imagine new technologies that could bring about protection of interests, which we already have universally, but there may not be any technology out there which can actually generate a duty. And that's quite a neat implication, I think, of your view. Just how much imagination and duty and commitment and time ought to be spent into thinking about what kinds of technological conditions could be brought about to satisfy these interests, which we don't have. So maybe at some point men could have an interest and possibly a human right to reproduction, right? So maybe.
I don't think it'll be high on men's list.
No.
Yeah, it's possible. Yeah.
There's some practical arguments for making about why that particular strategy wouldn't come about too soon. But I thought there's all sorts of virtues to this particular account. But one feature of it seems to have gone missing, and I think I've lost the thread of the argument, is that you could have an interest-based account with thick discussions of feasibility being tied or sensitive to social and technological conditions, and that can get you quite far. And I start to wonder why do we need to hang on to the concept of dignity? Where's it gone, in other words? I was with you yesterday, but I'm less with you now on the concept of dignity itself. Not so much the account. I think the account's quite powerful and strong, but why dignity? Where does it have any remaining role other than rhetorical appeal or force?
Okay, so it's a tough question because it kind of opens up the whole lecture from the beginning. Part of it is this. Some people think that, the big debate in ethics is between consequentialism and deontology. But my view is actually these are both mistaken, very similar sorts of views. And one of the ways that they're similar is that they share, historically, a very thin account of the good. So if you look at Bentham and Kant, for all their differences, they thought the human good was basically summed up by pleasure and the absence of pain. Incredibly thin, incredibly thin. And if you take that view of what human good is, and you try to make that the basis of ethics, the basis of morality, then I think Tim Scannon's right. You're led to a kind of consequentialism, a kind of hedonistic utilitarianism. That's the most, in some ways, intellectually coherent form of consequentialism. Because it looks like these detached experiences, pleasure, pain, what do you do with them? You maximize them. But then you discover there's no real place for rights there. There are sacrifices of individuals for the benefit of others. So what do? Well, the Kantian prescription is you try to base ethics without appealing, basic moral, without appealing to any kind of conception of the good. There's something about our nature as rational agents. But I think all the traditional criticisms of that view also hold that it's a kind of thin formalism that won't really generate. So where do we start? We start, I think, from the two combined. A richer conception of the good in light of the sorts of beings that we are. Not a thin, flattened out conception of ourselves as abstract reasoners, but as human beings and the value of what it is to be a human being, with the distinctive capacities we have that go beyond the formalistic kind of reasoning that Kant thought about, to things like having certain affective capacities, having capacities for certain kind of social relations and so forth. In tandem with that understanding of our nature, we work out an understanding of the good of beings of that sort. The value of being a human being, working together with what it is that makes beings of that sort flourish or not flourish. That, I think, is what's the basis of morality generally. So I don't think that human rights, when I say they're grounded in dignity and interests, are somehow... Human rights aren't distinctive because they've got a special grounding. That's a big mistake. That's Griffin's mistake, in my view. Their grounding is the same as morality generally. What's distinctive about them is that these typical grounds of morality, dignity and interests, generate some rights, which are rights, moral rights possessed by all human beings simply in virtue of their humanity. That's what makes them human rights. But they're not profoundly intellectually different from other norms in terms of what their grounds are. So in a way, what the dignity point there is doing is saying this notion of the good isn't something that's to be made sense of, some sort of free-floating interests that somehow have to be maximized. Humans are just the locations at which these interests are fulfilled or not fulfilled. No, they're interests of human beings. In fact, you don't really understand them as the interests that they are unless you understand them as interests of the beings of a certain sort who deserve respect of a certain kind. The two things, for me, come in together. So it's very important for me to have this. I'm still groping towards a clearer answer, right? But it's important for me to have it because I think I need to have an answer to the objection that once you bring in interests, what you're really doing is subsuming certain considerations under an aggregative norm that doesn't, in Rawls's famous phrase, take on board the separateness of persons. And my view is to say, no, I already took on board the separateness of persons in talking about them as interests. It's not something like additional, That's why I say the two things operate in close union. It's often hard to pull them apart. But you can pull them apart in some ways. For example, I mean, Grotius talks about the way in which the bodies of the dead in war get desecrated. And do we have duties towards, or do we have duties in respect to how the bodies of the dead are treated? Now, it seems to be very controversial to say how you're treated once you're dead affects your well-being. I mean, there are not implausible theories that will say it does. But nonetheless, we can agree that there's something wrong there without necessarily saying the person's life is made worse in virtue of the fact that he was eaten by dogs after he died. That's where the notion of dignity starts. You can get a sense of it as being detached from interests. And I think as you can see it operating there detached from interests, it also operates in unison with interests, typically, in generating human rights. And that's part of the story why the aggregative approach to interests is wrong. I know that's very, very vague.
Yeah, no, I'm with you on the plausibility of a pluralistic theory of basic human goods. Yeah. Right, you could have 7 on them if you're finis, or fewer, or more, and there's nothing objectionable in talking about part of what makes a human's life go better or worse is their interest in those, that plurality of basic goods, in those basic goods. And a further move that you could make is to say, well, the basic goods are also incommensurable. Sure. And irreducible, and that's why talk of aggregation of interest won't work. Now, I think you can accept that, though. You can accept that there's a plurality of basic goods, but still wonder about what work the concept of dignity is doing. Right? If you've got the concept of several plurality of basic goods and our interest in those, and they're incommensurable and irreducible, those seem to be more transparent and clarifying kinds of concepts. And so the concept of dignity, I mean, the example of what you can and can't do to the dead is a great example of how dignity really does make sense. Mm. But I'm starting to wonder whether that means that dignity might have a special, might play a really relegated role in explaining only particular kinds of particular interest, but not general categories of interest. So I'm just wondering whether dignity really is, right, it's given a prominent role as being among the foundations of human rights, but my inclination, my intuition is it's actually going to play a rather small and narrow role in identifying some particular interest, but not a general category.
Okay, I mean, my view is the opposite, that in a way that it plays a role across the board, but by itself is not sufficient to generate anything like the sort of recognizable list of human rights that we acknowledge. But I suppose one of the ways to try to bring it more into focus is thinking about some of the human rights norms that are particularly related to discrimination. And you might think that part of what's going on there is a failure to acknowledge certain kinds of fellow humans, women, the poor, gays, as being of equal status with the rest of us. That they're in some sense inherently defective, in some sense disordered, as someone said. Or as Aristotle thought that women are sort of like defective males, etc. Now, that's not directly a claim about interests. That's directly a claim about the kind of being that you're dealing with. And it seems to me that if you were thinking about, again, back to this project of really trying to make sense of the human rights movement, that a lot of the human rights movement would be about a claim that, look, what's going wrong here, before we even get to talk of interests yet, is that certain categories of human beings aren't being recognized as having an equal share in the dignity of being a human being, because they're seen as, in some sense, by being human, by being female, by being black, by being poor, this shows that they're somehow different. They're somehow of a lower order. We can treat them in some ways in the way that we think it's legitimate to treat animals. So if there is this kind of strongly egalitarian dimension to the human rights movement, I think that there is, dignity is what's trying to pick that out. but it would be picking it out across the board, right? It wouldn't be sort of saying, so I disagree with people like Alan Buchanan who say, well, this is a specific feature of some rights as opposed to others. I think it's generally relevant, although it might have more of a role in explaining the content of some rights as opposed to others.
It sounds like that could be dignity is now transformed into equality, though. You've got
it's equal dignity.
Yeah.
It's but equality of what? I mean, and also, I mean,
Sorry.
you make the point about these. I mean, someone like Finnis, who has the kind of objective list and has the incommensurability objection to aggregation. Although, of course, there are people like Sen who think the incommensurability objection can be taken on board within the theory of maximizing. But anyway, Finnis also thinks the notion of dignity is indispensable, and it is precisely this notion of equal dignity. Where I differ from him is that he thinks that it's a dignity possessed by all members of the human species equally. So even the most defective, sort of psychologically damaged, retarded individual has an equal share. And I think that's a much more problematic claim, that just because I belong to a species, which as a species has these capacities, that gives me equal dignity, even if, in my own case, these capacities can't be actualized. So we differ there, but we don't differ on the point that still the notion of dignity has to be in place. And it's this notion of dignity which, along with the things that you mentioned, I mean, there isn't just one reason not to be a consequentialist, there are probably 500 of them, right? But this is a pretty central one.
Thank you, that's very helpful. We have two follow-up questions, and that'll be all we'll have time for. So first Jeremy, and then we'll...
Thanks. My question relates to claiming human rights, making claims against others, and positive facilitation of those rights on the parts of states. Because I want to be clear that I understand your position. You mentioned how there are certain kinds of rights where it's unclear who the claim will be against, and it may be dependent on institutional structures. And you mentioned education. So I think in a country like Canada, where we have a very strong educational infrastructure, if any person or subclass of persons were being excluded from education, the natural person to claim it against would be the state. But there are certainly countries which lack the infrastructure to deliver education, and one can even envision a state that doesn't see it as its obligation to provide education and makes no attempt to do so. So do citizens in such a state not have the kind of claim against the state that perhaps someone living in Canada would?
I think they might not. You might have a society that says, look, we have an education system that isn't run by the state. It's run by a series of charitable bodies. And they're impeccable in how they operate. They're impeccable in terms of admissions, in terms of providing a good education, broad, liberal education. It's not brainwashing, anything like that. And then the point would be, well, okay, now I've got a right to education. In these circumstances, against whom do I claim this right? And you might say, well, they would differ from Canadians because the primary duty bearer there might be these charitable organizations. Now, what happens if these charitable organizations suddenly start behaving in a not so benign way as I've been describing? Then we're talking about secondary duties, duties that arise when the primary duty bearer is failing to do what they should be doing. And then it could be that the state has to step in at that point. Why? Because the state has the capacity, let's say, as compared with all other possible actors, to do something, either to make the charitable bodies come into line, or else to make alternative provision in the case where the charitable bodies, for whatever reason, are failing to do what they're doing. So the thought is, I want to preserve this flexibility in the account. I think it's an attractive feature of the account that I'm not tethered to saying, well, if it's a human right, the primary responsibility has to be on the state. I think the primary responsibility can vary from case to case. And I think it's, some of these political conceptions of human rights, I think almost, one example would be the claim, which I think Thomas Pogge, Charles Bates make. They say, look, a human right is distinguished by this feature, it's political in this way too, that its primary obligations only apply to the state. And that leads you to the situation where if you have, say, a man who is torturing his wife, is that a human rights violation? All you know is that he's torturing his wife. And both Pogge and Bates have to say, not necessarily. It's not necessarily a human rights violation because the state could be doing all it reasonably can to stamp out domestic violence. And if it's doing all it reasonably can, it's some other kind of wrongdoing, but it's not a human rights violation. And I think this is an unnecessary constriction on our language of human rights. The primary bearers of the responsibilities correlative to human rights can be various agents, not just the state. And it's just a matter of reasoning in particular contexts, who bears the primary responsibility. Though the reality of the modern world is, for many of these rights, especially the ones about providing goods, the state will be the primary duty bearer. But it's not fixed into this. If someone's an anarchist and says to them, look, I'm an anarchist on human rights grounds, I don't think this is a conceptually absurd position. It might not work for other reasons, but there's nothing incompatible with saying the primary duties of human rights fall on agents other than the state. You've just got to make the assessment in those particular circumstances.
So I have a question that's somewhat...
Another one, Dan.
Yeah, but it's somewhat different, and it arose from your discussion, which is, and it exactly, tries to look a little bit at the discourse, and so someone who's not sympathetic to some claims about human rights may say, look, this is the sort of stuff that politics is about. So let's take... We don't need to envision countries. There's one not far from here in which there is a big debate about health. And some people may say, look, there is a valid political debate to be made with regard to the question, you can phrase it in all sorts of ways, what we owe to each other, what the state owes to people, and so on. But we want to... And we think we have a particular view about this, but we can also have a kind of meta view about this, that this is the sort of thing that should be discussed, that should be the subject of normal politics. And those who favor extending healthcare, say, and for the record, I'm largely on their side, but they're cheating in a way. They're trying to win the argument by saying we cannot have an argument about this because that's a matter of human rights, and by that in a way close the debate. By that say, well, once it's a human right, then it's outside of normal politics, and so there is a kind of interplay with regard to big P political discourse, with regard to what belongs to small p political discourse, which shrinks once you expand the domain of human rights. And so some people may say, I'm sympathetic to the idea of human rights, but I'm actually favorable to views that want to keep them small, narrow, like O'Neill's account or like Griffin's account, exactly because I want to give more room for political discussion, political debate of this sort.
So the argument is that if they're acknowledged as human rights,
they're somehow taken outside of normal politics. So here is a real example in real life. So debates about rights are many times considered the domain of courts, and to some extent. So when you're unhappy about a political outcome, then you go to court and say, well, that's a human right. I mean, I'm kind of expressing here a view of some people who are against the expansion or proliferation of human rights discourse. And in a way, I'm not Waldron, for example. So Waldron might say, or people of Waldronian sympathies might say, the right place for discussing these sorts of questions is kind of normal political discourse. And by expanding the discourse on human rights, we're almost necessarily narrowing down and also perhaps making normal political discourse less important. And if we want, for example, an engaged political community, then that's not the right direction for a polity to take.
I think there are sort of contrasting things you're saying. So on the one hand, you could be saying, look, human rights don't belong to ordinary political discourse, so let's keep them small, right? That's one line of thought. But surely Waldron doesn't want to keep human rights small. He thinks human rights, a pretty long list of human rights, of the sort that I would buy into. He just thinks, but it's a mistake to think that the best way of dealing with this long list is through the courts.
Yeah.
So, and Griffin's doesn't really work because he doesn't really have, he thinks his account is as long as mine, right? Except that he's not into the right to work for some reason I haven't quite been able to understand. So what I would say is, because I don't have a political view of human rights, in the sense that I don't think of the concept of human right as of its nature political, I'm open, I can stand back from this debate and say, look, it's an open question whether in fact human rights should be particularly associated with courts and taken out of normal politics, or they shouldn't be. And in fact, the answer to that question might vary from society to society. If you come from a society where the legal system is riven with nepotism, and it's people appointing their nephews to replace them, then you might think, well, absolutely not have the courts in charge of it. There might be another legal system where sort of very strong populist views are against rights, but the judges belong to a kind of liberal elite, will protect the rights. In that case, you might say, yes, in this particular setup, the courts should have a special concern for rights. But I think my position is appropriately neutral with respect to that issue. It will vary from case to case. And it's a big mistake. I mean, of the political view, it buys in, it has the danger that it links human rights with a particular institutional framework for implementing rights. And then people think, oh yeah, but if we have to buy into human rights, and we have to buy into judicial review, we have to become a replica of America. It doesn't follow. That's just one way in which you might try to embody human rights. There might be other ways that work better for other societies.
Thank you. Chuck, please join me in thanking our speakers.
Thanks very much.